What happens when a violent assault is filmed and posted on social media for the world to see? Today, we watch as Plea, a young mother, faces sentencing for her role in the brutal robbery of another young woman. The prosecution paints her as a remorseless participant in a vicious group attack. Her defense attorney portrays her as a terrified follower who made a terrible mistake, a victim of circumstance who has already overcome immense personal tragedy, including the murder of her son's father. With her co-defendants already serving hard time, Pettis is pleading for a second chance on probation, but the state is demanding prison. As we dive into the arguments, one question hangs over the courtroom. Will the judge see a monster or a mother worthy of mercy? Stay with us as the final judgment is delivered.
John, who was the prosecutor?
It was Tom Nesbitt.
Thank you. All right, we're going to go on the record. Court is calling 2020 CR 11695, State of Texas versus Leda Pettis. Can I have the parties announced for the record for the state?
Tom Nesbitt.
For the defense?
John Winter.
And are you Ms. Pettis? I need you to unmute. Are you Ms. Pettis?
Yes.
We're proceeding by video because of the pandemic. Any objections from the state?
No.
No. Any objections from the state?
No, Your Honor. Sorry.
Any
No.
objection from the defense?
No, Your Honor.
John, this reminds me of whenever I swear people in, and then I ask them to state their name, they do it, and then I say state, and then the witness says Texas.
They're not wrong. They're
You're not wrong,
about
no. All right, Ms. Pettis, I'm going to show you what's entitled Defendant's Consent to Plea by Video Conference. Did you review?
The court is now moving past the initial procedural steps and getting to the heart of the matter. The judge has confirmed the defendant, Plea, understands the charge against her and is knowingly entering a plea. The defense has waived the formal reading of the indictment, which is a common time-saving measure. An indictment is the formal accusation by a grand jury that there is enough evidence to charge someone with a serious crime. By waiving the reading, the defense is acknowledging they know exactly what the charges are. This is standard, but it marks the official start of the high-stakes legal battle. The groundwork is laid, and now we will hear the terms of the plea agreement that will decide Leah's fate.
That document with your attorney? Did you understand it? Did you electronically sign it?
Yes, ma'am.
Court will find that the defendant has knowingly and voluntarily consented to appear by video. Ms. Pettis, I'm showing you what's entitled Application for Deferred Adjudication or Community Supervision. Did you review that document with your attorney? Did you understand it? And did you electronically sign it?
Yes, ma'am.
Counsel, I'm showing you the acknowledgement of discovery. Have you received all the discovery in this case, and did you review it with your client?
Yes, Your Honor.
Court will find that the state is in compliance with discovery. Ms. Pettis, I'm showing you what's entitled True Bill of Indictment. Did you review that document with your attorney? Did you understand it?
Yes, ma'am.
Counsel, do you waive the reading of the indictment?
We do, Judge.
State, are you proceeding on the indictment as presented?
Yes.
Ms. Pettis, I'm going to show you what's entitled Court's Admonishment and Defendant's Waivers and Affidavit of Admonitions. Did you review that document with your attorney? Did you understand it? Did you electronically sign it in all the appropriate places?
Yes, ma'am.
Did you understand what you're charged with is robbery? That's a second-degree felony. The range of punishment is anywhere from 2 to 20 years in prison and up to a $10,000 fine. Did you understand?
Yes, ma'am.
If you have a plea bargain agreement with the state, the court does not have to follow your plea bargaining agreement. If for any reason the court does not follow your plea bargaining agreement and gives you more than you bargained for, the fact that you entered a plea will not be used against you, and you will be allowed to withdraw.
This is the moment where the central conflict of the entire hearing is established. The judge is laying out the terms of the plea bargain, a recommended sentence of 3 years in prison. However, the defense is asking the judge for something entirely different: deferred adjudication, a form of probation that could eventually lead to the charge being dismissed. But look closely at the language. The state opposes this application. This means the prosecutor will actively argue against probation and for the full 3-year prison sentence. The defendant is now in a precarious position. She has pleaded no contest, but her freedom hangs entirely on whether her attorney can convince this judge to overrule the state's recommendation and grant her a second chance.
Your plea. Did you understand?
Yes, ma'am.
Did you understand you have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state would call, and the right to remain silent?
Yes, ma'am.
Did you understand by entering this plea bargain agreement, you were giving up those rights?
Yes, ma'am.
And did you intend to give up those rights and enter into a plea bargain agreement in this case?
Yes, ma'am.
Did you understand if the court were to grant your application for deferred adjudication, if for any reason your deferred adjudication were revoked, the court could find you guilty, not grant you community supervision, and sentence you up to 20 years in prison? Did you understand?
Yes, ma'am.
Counsel, has your client been able to provide you with any defenses to this offense?
Yes, Your Honor.
Do you believe she has a rational as well as a factual understanding of the charges against her?
Yes, I do.
Do you believe she's currently competent and was legally sane at the time of the offense?
I do.
Ms. Perez, has anyone threatened you, coerced you, or placed you in fear to get you to enter this plea?
No, ma'am.
Has anyone promised you anything other than the plea bargain agreement to get you to enter this plea?
No, ma'am.
Are you satisfied with the way you've been represented?
Yes, ma'am.
Are you a U.S. citizen?
Yes, ma'am.
Court will find that defendant has knowingly and voluntarily waived her right to jury trial. Show you what's entitled plea bargain page. Did you review that page with your attorney, and did you understand it?
Yes, ma'am.
According to the plea bargain agreement,
With the evidence phase concluded in record time through stipulations, we are now officially at the sentencing stage. Stipulating to evidence means both sides agree to certain facts without needing to call witnesses. In this case, they're agreeing that the police reports and witness statements are sufficient evidence. This isn't a trial about guilt or innocence. Leah has already entered her plea. This is a hearing about punishment. The judge has deferred a finding of guilt to consider the defense's application for probation. This is a crucial defining moment. The stage is now set for Leah Pettis and her attorney to make the most important argument of her life, why she deserves to walk out of this courtroom on probation instead of being sent to prison.
punishment is to be assessed at 3 years in the prison. There's a $500 fine. State opposes your application for community supervision or deferred adjudication. There's to be restitution in the amount of $2,131.29 to Jasmine, Jasmin, Reyes. It's to be payable to victims, paid jointly and severally with co-defendant Nancy Ramirez and Angelina Macias. And there's to be no contact with Jasmine Reyes. Did you understand that to be the agreement?
Yes, Your Honor.
Defense, is that the agreement?
It is, Judge.
State, is that the agreement?
Yes.
Next, I'm showing you the paragraph entitled Waiver of Appeal. Did you review that paragraph with your attorney? Did you understand it? Did you electronically sign it in both places?
Yes, ma'am.
Do you understand by signing that you're waiving your right to appeal? The only items that can be appealed are written pretrial motions that have been filed, heard, and ruled upon by the court. Did you understand?
Yes, ma'am.
Counsel, have there been any such motions?
No, Your Honor.
Then to the offense as charged in the indictment, how do you plead? Guilty, not guilty, or no contest?
No contest.
State any evidence to support the defendant's plea.
We offer Exhibit 1 and attachment.
Any objections?
No, Your Honor.
Ms. Perez, I'm going to show you what's entitled Waiver and Consent to Stipulation of Testimony and Stipulations. Did you review that document with your attorney? Did you understand it? Did you electronically sign it in all the appropriate places?
Yes, ma'am.
Again, did you understand you have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state would call, and the right to remain silent?
Yes, ma'am.
Did you understand that today the state will be presenting evidence in the form of witnesses' statements and police reports, but most importantly, there will be no live testimony? Did you understand?
Yes, ma'am.
Court will find that defendant has knowingly and voluntarily waived and consented to stipulation of testimony and stipulations. The court will accept it to evidence, states Exhibits 1 and attachments, and review the same. All right, after reviewing states Exhibits 1 and attachments, the court will find there sufficient evidence to find you guilty. However, the court will defer finding of guilt as you've applied for deferred adjudication. Could I get a date, Norma, for sentencing, please?
Yes, ma'am. Give me 1 second. Judge, right now we're looking at about October 20th.
All right, Ms. Pettis, we're going to come back.
The defense attorney is executing a classic strategy, humanizing the defendant. He's building a narrative of sympathy and redemption. He brings up that Leah is a single mother whose son's father was tragically murdered, forcing her to raise a child alone. He highlights her ambition and efforts to improve her life, pointing out that she went back to school to get her diploma and is now certified to be a lash technician with plans to work at her sister's salon. The goal here is to present Leah not as the robber described in the indictment, but as a resilient young woman who has overcome immense hardship and is on the path to becoming a productive member of society. He's trying to convince the judge that she is not a threat to the community, but rather a person worthy of rehabilitation.
On October 20th, you'll need to appear in person in the courtroom. It's the 187 District Court on the 4th floor, located at 300 De La Rosa. You need to be here on October 20th. Do you understand?
Yes, Your Honor.
Okay, I got it. All right, thank you. Please proceed.
Thank you, Judge.
Mhm.
And so you're aware of that, correct?
Yes, sir.
Okay. Now, let's talk a little bit about your situation. Now, you heard what your sister stated about you have a son, right?
Correct.
This is a calculated and very smart move by the defense. They aren't just talking about taking responsibility, they're showing it, the restitution owed to the victim. Jasmine is over $2,100. By having Leah bring $400 in cash to the hearing, the defense provides a tangible demonstration of remorse. It sends a powerful message to the judge that Leah is serious about making things right. It's also a strategic jab at the co-defendants. Since they are already in prison for 6 and 8 years, they aren't in a position to pay their share. This positions Leah as the only party who can realistically make the victim financially whole again, a key argument for why she should be kept out of prison and on probation where she can work and pay.
And make sure you speak up nice and clear.
Correct. Yes, I have a son.
Yes. And he's 2 years old?
Yes.
Okay. And where is he right now?
Right now, he's with my mom.
I'm sorry, could you speak up a little bit, please?
He's with my mom right now.
Okay. And so you have family who helps you, through things like this, helps you with your son, helps you with things, correct?
Yes, sir.
Okay. And what happened to his father?
He was murdered
And when was that? When was he murdered?
in 2018.
In 2018? So it's been difficult raising your son alone, correct?
Yes, sir.
But you managed to do it, I'm sure, with help from your family. Is that right?
Yes, sir.
Okay. And what have you done to put yourself in a position? Well, let me back up a little bit. According to the PSI, you had to drop out of school in order to have your son, correct?
Correct.
But you still managed to go back and get your diploma, right?
Correct. Yes, I got my diploma from SA Leadership.
Okay. And what have you done other than the diploma? What have you done as far as like any kind of vocational training, anything to better yourself for the future and your son's future?
I got certified to be a lash tech, and now I'm looking to get licensed to practice on people.
Okay. So your plan is to be a licensed lash technician, right?
Yes.
And that's something you could work maybe with your sister's salon, right?
Yes.
And you feel that would provide good support for you and your son?
Yes.
The prosecutor, Tom Nisbet, immediately goes on the attack, attempting to dismantle the sympathetic image the defense has carefully constructed. He starts by pointing out that in her interview with probation officers, Letta seemed to be blaming the other girls, downplaying her own involvement. Then he drops the hammer. The entire brutal incident was captured on an iPhone and posted on social media. This is a devastating detail. The crime wasn't just a robbery, it was a public spectacle designed to humiliate the victim. The prosecutor brings this up to show that this wasn't just a simple mistake made in fear, but a cruel and brazen act. He's now questioning her sincerity and forcing her to confront the public nature of her actions.
Okay. And so you know that there's money owed to this young lady because of some items that were taken from her. There was a cell phone taken and some jewelry
The prosecutor has just cornered the defendant with a brilliant and brutal question by asking Leah what she would want if the victim Jasmine were her own sister. He forces her to confront the hypocrisy of her position. Her answer is telling. Even in this hypothetical scenario where her own family member is the victim, she still suggests probation would be an appropriate punishment for the prosecution. This is a goldmine. It suggests a profound lack of empathy and a failure to grasp the true violence and terror inflicted upon Jasmine. The prosecutor is using this moment to argue to the judge that Leah's apology is hollow and that she doesn't truly understand the gravity of her crime.
Is well taken. And we've discussed that, right?
Yes.
And you know that the amount of restitution that's owed is $2,131.29, right?
Yes.
Now, you also know that the two young ladies who were charged along with you, they've gone to prison for like 6 years on one and maybe 6 or 7 years on the other, correct?
Correct.
So chances are the person who's going to be responsible for paying that off is the person who gets probation. That'd be you, right?
Yes.
Okay. Now, are you willing to pay off that restitution, to do what you can to make sure that this young lady is made economically whole?
Yes.
Okay. Did you bring any money with you today to help in that?
Yes, I brought $400.
$400.
Yes.
Okay. And you want to pay that towards restitution, right?
Yes.
Okay. And now there's no way that you can make up for what happened, but would you like to tell the court and Jasmine, would you like to tell them anything about this situation?
I would like to say I'm sorry to Jasmine. I know that my actions affected her a lot, and I learned from my mistakes, and it's something I will never do again. And I don't want to ever do this to anybody else, and I don't want my son to pay for my mistakes.
And you're asking the judge to give you a chance on probation, right?
Yes.
Okay. Now, you heard the prosecutor state something along the lines of,
You can feel the defense attorney doing damage control after the prosecutor's sharp cross-examination. John Winter steps in to guide his client back on message. He has her explicitly state that she hit Jasmine and participated of her own free will. He knows that denying responsibility at this point would be fatal to their chances of probation. However, he is also trying to minimize her culpability. He makes sure she clarifies that she wasn't the one who dragged Jasmine from the car and didn't know about the plan to steal her belongings beforehand. He is trying to walk a razor's edge, admitting to assault to show accountability, while framing her as a follower who got swept up in the moment, not a ringleader who orchestrated the robbery.
you don't feel that you need any treatment for alcohol. So are you willing to do whatever the court requires you to do as part of
Yes.
the probation?
Yes, whatever it takes.
Okay.
This is the defendant's final direct appeal to the judge. Her attorney poses the ultimate question: why should you get probation? Lee's answer is a plea for mercy rooted in her identity as a mother and her plans for the future. She claims the person who committed this crime wasn't me and that she was lost at the time. She emphasizes her future goals and her willingness to do whatever it takes to complete probation successfully. This is her last opportunity to show remorse and convince the court that she is more than her worst mistake. The question now is whether this emotional appeal will be enough to overcome the violent facts of the case and the prosecutor's argument that she is not taking full responsibility.
I pass the witness.
All right, the state, do you wish to inquire?
Just a few questions, Judge.
All right.
Lita, in reading the pre-sentence investigation report, so the interview you had with probation, it seems to me like you're trying to blame the other females involved and say that you were just kind of along for the ride. Is that how you feel about this?
I feel like I did play a role in this, and I do take accountable for my actions, but I just also feel like I was scared at the time.
And also in the report that talks about any substance abuse problems, they indicated that you're not motivated for treatment. You don't need any sort of treatment for your alcohol problems?
I don't consume alcohol.
Okay, well, on when this offense happened,
At the time,
were you consuming alcohol then?
yes.
Okay. And you're aware that this incident was captured on an iPhone video and posted on social media. You're aware of that, right?
I never posted anything. I'm not aware if anybody else did.
Okay. And so are you admitting then to this court that you did play a part in this robbery, that you punched her, drug her out of the car, and left her on the side of the road while stealing her iPhone and jewelry?
I didn't take anything from her, but I did hit her.
Okay. And
The prosecutor delivers his closing argument, and he holds nothing back. He methodically lays out the state's case for why Leah Pettis deserves prison, not probation. He recaps the sheer brutality of the offense, a group of women dragging a victim from a car, assaulting her repeatedly, and filming the entire ordeal. He strategically reminds the judge that the other two participants received sentences of 6 and 8 years in prison. His core argument is that while Leah might be the least culpable of the group, she was still a willing and active party to a heinous crime. He concludes by attacking her credibility, referencing her initial statements that blamed others and her alleged lack of motivation for alcohol treatment, painting a picture of a defendant who is not genuinely remorseful.
Leda, if this were someone in your family, let's say hypothetically this was your sister, and she was drugged from a car, kicked in the head, punched, and things were stolen from her, and she was left on the side of the road with this videoed and put on social media, would you say, oh, probation's an appropriate punishment for that offense?
I mean, given all the requirements of the probation, yes.
Okay. Nothing further, Judge.
Counsel, anything further?
Yes, Your Honor.
Mhm.
So, Leda, since we're getting into what happened that night, were you the one of the girls who dragged the young lady Jasmine? Were you one of the girls who dragged her out of the car?
No, sir.
Okay. When she was dragged out of the car, what did you do?
I was confused and I was scared. I didn't know why this was happening. And so I felt like if I didn't do anything that they would do this to me. So I went ahead and hit her.
Well, and we want to make sure that we're clear on that. You know, of your own free will, took part in that, right? You saw them beating up Jasmine, and you took part in that, correct?
Correct.
And you're telling that you're not shying away from that in front of the judge, right? You're here to tell the judge you're taking responsibility for that, right?
Right.
And you're
Right.
telling Jasmine as well. You've already apologized once. You're telling her what you're responsible for, right?
Correct.
Okay. At the time that it happened, were you aware that they planned on taking her jewelry and her cell phone?
No.
Okay, but you saw it happen, right?
Yes.
And you got back into the car with these people.
Yes. I needed to go home. I was far from home and I didn't know what else to do.
Right, right. But like I said, you were aware of all of this, and you took part in striking her, right, and punching her.
Correct.
Okay, so we're not trying to tell the judge, that you didn't have anything to do with this, right?
Correct.
Right. But what you're telling the judge is that, you've never been in trouble before, right?
Right.
This isn't the kind of thing that Leda Pettis goes around doing, right?
Right.
The defense attorney makes his final stand, pushing back against the state's narrative. He passionately argues that if anyone in this case deserves probation, it is Lee. He emphasizes her clean criminal record, contrasting it with the extensive histories of her co-defendants. He reframes probation not as leniency, but as a constructive form of punishment that ensures supervision and critically allows for the victim to receive financial restitution. He circles back to his theme of redemption, portraying Lee as a young woman who, despite a traumatic past, is actively trying to build a better life for herself and her son. He argues that the interests of justice and the community are better served by rehabilitation rather than incarceration.
This isn't the kind of thing that you're going to do in the future. This is kind of a scary thing for you standing in front of the court, right?
Yes,
I mean, you're looking at your freedom here, right?
yes,
And it's all because of what? It's all because of what you did to Jasmine, right?
right.
So based on all,
The judge has rendered her verdict. I'm going to follow the plea agreement. I'm going to assess punishment at 3 years confinement. With those words, Le Pettis's hope for probation is extinguished. The judge has denied the defense's application and sided with the state's recommendation. She orders the restitution to be paid and recommends the victim be connected with assistance programs, acknowledging the deep harm that was done. The legal arguments are over, the sentence has been handed down, and Le Pettis is going to prison. Now, in the aftermath of this decision, the court prepares to hear a victim impact statement, a final poignant reminder of the human cost of this crime.
that, and like the prosecutor said, you know, if it happened to your sister, you may not feel good about somebody like that getting probation, right?
Right.
But you've got to tell the judge why you should get probation. So why should you get probation?
I should get probation because I'm a mother and I was lost at the time. That wasn't me. I learned from my mistakes. And
You have plans, right?
I have plans for the future.
You have plans for you, right?
And I'll do whatever it takes if I get probation to do what I need to do and complete my goals in the future for me and my son.
I pass the witness.
Anything further, State?
No, nothing further, Judge, just argument.
All right, you may step down. Were you putting anything on, Meredith?
No, Judge, just argument, and then later we'll have a victim impact statement.
I see. Okay. All right. Well, then I'll hear argument. State?
Your Honor, this is the type of offense that the state feels like probation is in any form is not appropriate. As you can see from the pre-sentence investigation report, as well as the reports and everything like that, this defendant participated with a group of people in removing a person who just wanted a ride home from a party, a young woman, from a car, continuing to assault her repeatedly while taking items, whether or not she admits to knowing that the items were being taken at the time, repeatedly being assaulted. And all of this was captured on a video. It's hard to identify, but the victim was able to identify some of the actors, which is why we were able to make cases on them. Other actors were not able to be identified. She was left by the side of the road and was very traumatized, as you can imagine. Just for some perspective, the two other female co-defendants, their applications were denied. One of them received 6 years and one of them received 8. So when the state made our original offer to this defendant, Ms. Leda Pettis, we took into account the fact that she does not have much in the way of criminal history, if at all, and of the group was probably the least culpable, but still very much a party to the offense and a participant. So for all these things, and
The final word in this case belongs to the victim's mother, Victoria Reyes, whose victim impact statement is absolutely heartbreaking. She powerfully describes her daughter's ongoing trauma, a physical head injury that will require surgery combined with the deep psychological scars of PTSD and depression. In a stunning moment, she directly challenges the defendant, questioning how one mother could inflict such pain on another's child, especially after having experienced the trauma of losing her son's father to violence. While she wasn't seeking a vengeful sentence, she firmly states that probation would not have been justice. In the end, the judge agreed. Leah Pettis was sentenced to 3 years in prison, bringing a close to this tragic case. Do you think the judge made the right call? Comment below with your thoughts. And be sure to subscribe for more in-depth courtroom analysis.
in addition, we don't really feel like she's taking full responsibility. it, based on what she told the officer, kind of made it sound like she was along for the ride. Also says in her tap that she's not motivated for treatment. When alcohol, what she claimed alcohol was to blame at the time of the offense. And for these reasons, Judge, we're asking that you deny her application and sentence her to the 3 years.
All right. And while we're on the subject of the plea agreement, I don't think I ever received what the terms of the plea agreement were. Can you set those out for me? Like, did she apply? Yeah, I just don't have any information.
It was 3 opposed, Your Honor. John, did she apply for both regular and deferred?
Yes, we applied for both regular and deferred adjudication. And the agreement was for 3 years TDC opposed to our application.
Okay, thank you. All right, counsel, argument?
Thank you, Judge. Leda is definitely the least culpable person involved in this, both in her actions, in her criminal history. My understanding, and I'm going off of memory, so forgive me if I'm wrong, but my understanding is the other 2 women who got sentenced had much more extensive criminal histories and also other cases, as well as this robbery case when they were sentenced. I don't know if they were sentenced on them or they were taken into consideration or what happened, but Leda is the one here who, if anybody should get probation, it should be Leda. She's certainly the least culpable in the actual offense, which I disagree with Meredith. I do believe that she's taken responsibility for it. She may not be the most articulate young lady out there, but she's certainly saying, what she did and what she's taking responsibility for. She's got a good family who's going to help her through this. When I told her that prison is a possibility today, she didn't shy away from that. She came to court. She made sure her son is safe with her mother. She's able to plan these things just like she's planned for the good things in her life, by getting her eyelash technician certificate, by working with her sister at that salon, which hopefully will lead to better things. She's had a difficult time. The father of her child was murdered. She's living in not assisted housing, but Section 8 housing now. But she's still trying to make plans for a better future. And, let's not forget, probation is still a type of punishment. It doesn't mean that she's not getting punished for this offense. She will be punished. She'll be held responsible. She'll be supervised. She'll have to make restitution to Jasmine. And she's willing to do that. She's willing to do these things because it's the right thing to do. And I think when you look at everything together, yes, it was a terrible thing that happened to Jasmine, and yes, Leda took part in that. But she's here to ask for probation, and I think that she can successfully complete probation. And I think that the interests of the community, of Jasmine, and justice are served by her getting probation.
All right. I'm going to follow the plea agreement that you entered into with the state. I'm going to assess punishment at 3 years confinement in the institutional division of the Texas Department of Criminal Justice. You will be given credit for any time that you've already served. I'm going to order restitution to Jasmine. What's her last name? Jasmine's last name?
Reyes, Judge.
Restitution to Jasmine Reyes in the amount of $2,139.21. Ordering that as a condition of parole. I'm also going to recommend, if it hasn't already been done, that the victim be put in contact with the Victim Assistance Program for possible help with any expenses that are not being covered by her insurance for medical care that she continues to need for both physical and mental issues. Is there anything further from either side?
No, Your Honor, just a victim impact statement when the court is ready.
I'm ready.
Okay, it'd be under Victoria Reyes. Victoria, are you there?
Yes, I am.
Okay, the court is ready for the victim impact statement.
Okay. Well, first of all, I just want to thank you, Judge, for everything that you've done right now. I'm a mother, so I've heard Leda's story of, the fact that she is a mother as well, which makes me ask, why was she out at this time? Why was she not with her son? The fact that I'm a mother, I would think that she would be trying to teach her son these values. And that's what a mother does. Right now, if she can even imagine someone beating her son, leaving him bleeding, having to have CAT scans done. My daughter has a mass in her head. She will need surgery. My daughter has depression, PTSD. She quit her job. She wasn't even going to go to graduation. That was her senior year. My daughter went through so much. And for Leda, I wasn't asking for her to serve as much as the other girls because I know they told me her criminal history, which she didn't have one. But the thing is, probation was not enough. That would not have been justice being served because I know she's the one who had less of involvement. But the thing is, it doesn't matter what you do. You steal a piece of gum versus to stealing something more valuable. Theft is theft. This is an assault as well. Even a small part that she took in it, but she's still accountable for it. And I understand that she has said she's sorry. And I'm not a hateful person asking, vengeful either. But all I want is, my daughter, justice being served, and this never to happen to someone else's child. And I hope she learns from this as well. And also not to hang around with those type of people that she was involved with, because obviously they were the wrong crowd. And I feel bad that now she has to pay for this, for that one time that she had to be involved. But at that time, she also had the choice to make. She could have just took off. She could have not took any part in it. And right now, we wouldn't be here right now. And that's all. And I've heard also as well that the father of her child was murdered. If hearing that and you've gone through something so traumatic, why would you do this to someone else? If you have passed through this as well, having support of your family, then why didn't they ever guide you on the right path to tell you don't hang around with these people, stay home and take care of your child? So I feel for them because I'm a mother, so I feel for her mother as well. And I just hope that she learns from this and never to do this again and not to associate with those kind of people. My daughter now is left to deal with the aftermath. And it's just hard because we can't take it back. We can't go back in time. I can't go back to that time to protect her. And now all I can ask is for justice to be served. And I'm happy that it has, because this can never happen to someone else. Thank you for your time.
You're welcome. All right. I'll remand you to the custody of the sheriff. Anything else from either side?
No, Your Honor.
Okay, very well. Have a good day,
Thank
John.
you.